he's called her 195 times.
What?
Yes. And
did you say 195?
yes.
Oh.
And even one of the calls, he said, email the judge and the prosecutor and the lawyer. And that day we received the email from the victim.
Oh, that's a lie.
Stop.
That's a fucking lie.
Hey.
Oh, no, we're not going to say that. Both privileges are hereby ordered revoked. Defendant's bond is set at no bond.
I don't give a fuck.
Okay, he's now in contempt. That's 93. Anything else?
She can be very vindictive.
Okay, so let's not say that out loud.
I'm gonna be very honest with you, Judge.
Okay.
I have no intention of paying a one penny. All y'all have just failed me. Give my last tears and blood, sweat, and tears into this. In March, I was in jail for beating him up. I'm hopeless, frustrated, and exhausted. And I'm done, sir. I'm mentally. I'm in middle school. I didn't pass. I'm not educated. I need to speak to me like a toddler. I would understand that better. Thank you.
Your name, sir?
Devin Miller.
All right. And Ms. Mahmood, is she here or no?
Yes, she is here, but I think she's having some difficulties right now.
Your Honor, we haven't received a payment since the last time we were here. It's $26.65 total. 25.65. I'm sorry.
25.
Oh. So I recently just received employment, so been waiting for my check to come between that time.
I have a note that $1,000 was going to be paid. I don't know why.
$1,000?
Okay. Well, how would you intend on getting this paid off,
sir? So I don't get paid until the 28th.
Until the what?
The 28th of June.
Okay, but all right, let's take that. And how much would you be willing? How much are you going to be able to pay?
So with me working weekly, I get paid $5.60 on a full.
On a full check, you get how much?
$5.60 minus tax.
Because I don't know how we're going to do this if she's not here, because I'm about to. I mean, my inclination is to issue a judgment.
Well, we've been having some difficulties in being uncooperative.
Pardon?
She was being uncooperative. I would hope that you don't throw it out because I'm really trying.
She was being uncooperative.
I apologize for interrupting. I have an IM out front, but she doesn't want to come to the courtroom because of a contact order between her and her husband.
We don't have one, sir, Your Honor.
Are you her husband?
Yes. May I explain?
Please.
Okay, so recently she's having a spat with me. She's just upset that she wanted me to apologize for a misunderstanding that we had before coming here.
Bro, this hearing is already messy before the judge even gets to the money. The husband says his wife is being vindictive, and the judge immediately hits him with, "Let's not say that out loud." Chuckle, that was a quick courtroom reality check. Then the payment issue comes up, and suddenly nobody seems ready to cooperate. But wait! The next person to speak is about to completely change the mood.
To court when she got verbally volatile with me, so she decided to.
Okay. That's fine. Is there a no contact order between the two of you?
No, there's absolutely not. She probably just said that just to make things worse on my end.
Well, they couldn't get much worse.
Yeah, I don't.
I'm not really sure. She can be very vindictive.
Okay, so let's not say that out loud. Okay. Can you go down the hall and
sign her into Zoom?
No. She's here. Yeah, well, ask her if she's going to participate in the hearing. Him over here.
Sir. Yeah, I'm seated.
All right. And what's your name?
Mariam Mahmood.
All right. There's a total amount of $25.65 owing. Was there a method by which you were intending on getting this paid? Or do you know?
I'm gonna be very honest with you, Judge.
Okay.
I have no intention of paying one penny. No intention of paying 1 penny. I've been with Barnes and Barnes since 2021 in this place. I've been with Barnes and Barnes for about 6 years now. Before that, I was in different apartments with Barnes and Barnes. Before that, I've been in EMU since I was 16. Eastern Police, Ipsy Police, all y'all have just failed me. I've been begging Barnes and Barnes to fix my house for a simple fan for heat in the winter. I'm having to take money out of my pockets to keep myself fed. I would rather sleep in my car than fight for a house, because along with this court case, I'm dealing with my dad who decided to touch me for 6 years and get away with it. Along with that, I'm dealing with my mom not cooperating and being in cahoots with him. I'd rather win a settlement than fight for this and give my last tears and blood, sweat, and tears into this. My husband doesn't understand how to speak to me nicely. That's why we're not standing here together.
Nah, wait. She finally speaks. And this is not just about rent anymore. She says she has been failed by the police, her landlord, and basically everyone around her. Then she drops an explosive personal accusation against her own father and explains the chaos at home. So I look at the courtroom shift. This went from a simple payment dispute to something deeply personal. But the judge still has a decision to make.
And I'm not gonna stand next to a man who doesn't know how to open the right door instead of the left door and snap at his wife. I'm not going to do that. I walked out because in March I was in jail for beating him up. I'm not gonna stand here and go out of my character and act irate when I don't want to fight for something that's mine. That's not. He claims that it's his more than mine. I brought him into my house. I gave him my car. I gave him the clothes on his back. I'm not going to fight for this anymore. I'm exhausted, tired, and hopeless. Ipsy Police was in my house today at 5 a.m. when I asked for harassment. I filed a PPO. I'm getting no help. I'm hopeless, frustrated, and exhausted. And I'm done.
Okay. I just had to make sure, which is why I wanted to do it in the courtroom, that I was going to find no tribal issue. I was going to issue a judgment to the plaintiff. And I just wanted to make sure that you understood what the court was doing, which is why I wanted you here. All right. So the court finding no tribal issue, I'll enter a judgment for possession and money. It looks like you requested. For possession and money as to both defendants. Total amount, the $25,600, that was inclusive of costs, correct?
Yes.
In the total amount of $2,565. And an order of eviction or writ will issue in 10 days. All right, thank you.
Sorry, could you say that again? I speak 3 different languages. I'm not American, I'm British. So I didn't understand one word that came out of your mouth. I'm sorry, sir.
The whole thing?
You're throwing legal words at me, sir. I'm mentally,
Ma'am,
I'm in
all right.
middle school. I didn't pass, I
Okay.
speak 3 different languages. I'm not educated.
Okay.
So I don't understand when you throw legal terms at me. I need to speak to me like a toddler. I would understand that better. Thank you.
Okay, now she reveals she was actually in jail for beating up her husband. Bro, what is happening in this hearing? She says she's exhausted, hopeless, and completely done fighting over property. Then the judge explains he was ready to issue a judgment. And that's when she admits she doesn't understand the legal language at all. Chuckles, she literally asks him to explain it like she's a toddler. And what the judge says next makes the consequences very clear.
I'm issuing a judgment. I'm signing a judgment, a piece of paper indicating that plaintiff, your landlord, has the right to possession of the premises.
Okay, so
Unless $2,565 is paid prior to July 1st or by July 1st. If it's not paid by July 1st, they can then file for what's called a writ of restitution or an order of eviction to have you move. Either at that point you can move by then or you can pay the money by then. If you fail to move, what will end up happening if they file that order of eviction, the court will sign off on it. And then what will happen is the sheriff, another police agency, or the sheriff's department or a court officer will show up and will, if you haven't vacated the premises, will remove you from the premises.
Yeah, and I know how the eviction process works. I just don't. I have lawyers in my family, but I'm more on the medical side rather than the lawyer side. But
Wait, this is where the reality hits. The judge breaks down the judgment in simple terms. Pay the $2,565 by the deadline, or the landlord can move forward with eviction. No complicated courtroom language this time, just straight consequences. And she says she already understands the eviction process because she has lawyers in her family. So that hearing finally wraps up. But the next case goes from calm to absolute chaos in seconds.
I appreciate all your help, and sorry
All right.
my husband and I aren't cooperating today.
Thank you.
Thank you, Your Honor.
Good morning again, Your Honor. Andrew Meyer on behalf of Joseph Taylor. Mr. Taylor, could you state your name for the record?
Joseph Taylor.
Thank you. Your Honor, this is time and date set for probable cause conference. This time we're asking the court to set this for the next available preliminary exam date.
Discovery is complete.
To my knowledge.
People had their witnesses available the second.
Yes, Your Honor.
Preliminary examination will be set July 2nd, 2024, 9 a.m. That is in person, before Judge Washington.
I wanted to address Bond before his,
Yes, go ahead.
he has been contacting the victim.
I'll just go.
In this case, and we also asked you to report his jail phone call privileges. He's he's called her 195 times.
What?
Yes. And,
Did you say 195?
yes.
Oh.
And, even one of the calls, he said, email the judge and the prosecutor and the lawyer, and that day we received the email from the victim.
Oh, that's a lie.
Stop.
That's a fucking lie.
Hey,
Oh, no, you're not gonna say that. Phone privileges are hereby ordered revoked.
Hey.
Defendant's bond is set at no bond.
I don't give a fuck.
Okay, he's now in contempt. That's 93. Anything else?
Bro, the next defendant might have just talked himself into a much bigger problem. The prosecutor tells the judge he's been contacting the alleged victim 195 times. Wait, 195? Then he allegedly tells her to email the judge and prosecutor. And suddenly he shouts that it's a lie. Look at the judge's reaction, zero patience. Then comes a bombshell. Bond revoked, and bond in contempt. Just like that.
Okay, I'm gonna need an order. Contempt. You got 93 on that. His bond's been revoked. It's 0, and he's got a preliminary examination. Good luck, Judge Washington. What are we doing?
Your Honor, I was just going to ask for a short adjournment here. Just going to look in to see if we can get him. Sorry, I don't know why I always say here.
I don't either. I don't know. Because I guess you asked for adjournments there too.
Yeah.
All right.
Yeah, I need to request an adjournment just to see if I can get him into.
May 16th, 2024, without objection.
May the people consider that bond?
You may.
Thank you. Your Honor, at the time the defendant was arraigned, he requested a $50,000 surety bond, and that would rate the alleged defendant $50,000 surety bond with 10%. I think that the asking the court to review that for an abuse of discretion. This is the defendant's 11th or 12th OWI. So you can see his priors are from 2020, 2018. There were 2 in 2012, 2005, 1995, 1993, 1992, 1989, 1988, and 1986. And specifically, he got for OWI.
What year?
2022. The concern for people is the risk to the public of the defendant. Professor plays on the scrum cover, and there's been no indications that he's violated this right directions this morning. But this pervasive and ongoing history of OWI is of extreme concern to the people, the safety of the public.
Your response.
Oh, Your Honor, Mr. Radke is a Navy veteran, disabled veteran from 1982 to 1985 with an honorable discharge. He's Michigan born and raised. He resides in Wayne. He regularly attends AA meetings. Last time he attended an AA meeting was yesterday, and he attended 2 of them. He also let me know that he voluntarily has looked into checking into an inpatient treatment program in Detroit. I believe it's called Life Challenge Inpatient Treatment Program. It is Christian based, and he let me know
How
that.
come he isn't in an inpatient treatment program now?
Your Honor, he has been going to AA meetings
And, you know, it's an up and down battle with Mr. Radke. And
I understand that, but I also understand that he served prison time for drunk driving. Was released in 2022. And by 2024, I'm back here again with this. Right?
yeah, that's correct, Your Honor.
What was the alleged BAC in this matter?
Yeah, that's a really good question. We're still awaiting the blood results. This was a single vehicle crash that occurred. The defendant.
There was an accident?
Yeah, he crashed, a single vehicle crash. And the defendant.
Mr. Allen.
All field sobriety tests, all PBTs, and the blood, as the blood draw as well, and we did get a warrant. So we're still waiting on that, but we did charge the case given the history. And I will let the court know too, that at the time that the defendant was booked into the Washtenaw County Jail while awaiting medical examination, he did submit to a PBT at the jail, which was a .147.
We're on to another defendant, and this one has a seriously troubling history of OWI cases. The prosecutor lists convictions stretching back decades. 2020, 2018, 2012, 2005, and even further. Side the defense tries to explain that he's a veteran, attends AA, and is looking into inpatient treatment. But the judge isn't ignoring the history. Then they reveal a booking alcohol reading of .147 after a single vehicle crash. And now the judge has a big decision to make.
That was at the time, 147 at the time of booking?
At booking, that's right, Your Honor. But of course, the court knows we won't be able to use that number for our case, but that was the PBT at the time of booking.
Anything else, counsel?
Your Honor, Mr. Radke was arraigned in front of the Honorable Magistrate Fink. I believe she appropriately set the bond here at $50,000, 10%, with a scram tether with a no drinking, no driving standard bond conditions. Yes, there was an accident. Nobody was physically injured. He has been on scram.
We had a blessing.
He had a blessing, but nobody, from what the alleged report says, nobody was injured. He checked in today early at Community Corrections. His agent is Mr. Levitt. They downloaded they gave him a main base device for his home so he can continually test at home. He has had no issues since he's been arraigned. He is compliant with all of the bond conditions here. And he's
Counsel,
here.
you say that to me, but we're a week out from arraignment. It's a week.
I know, Your Honor, but you know, I'm just trying to.
No, go ahead. You make your argument.
Yeah, I mean, I'm just trying to let the court know that, you know, Magistrate Fink heard both arguments. I believe she set the bond at an appropriate bond. If Mr. Radke would have known that the bond would be raised, he would have never posted a $5,000 bond that he had to use on his credit card. His son, he had to call his son here. His son is in the courtroom now, trying to take care of these matters. I'm just asking this court if it would have any leniency for Mr. Radke to allow him to continue to do what he's been doing and get these matters taken care of here.
I believe that given the defendant's record in this matter, given the fact that we don't have the test back, but he was almost a .15 at the time that he was booked in, that further that there is an accident that has occurred. Also, given the defendant's record that he had just come off parole, basically in 2022, we're back in 2024. He's done this again. This is not by any stretch of the imagination necessarily an attempt to punish the defendant, but I believe that the defendant, he may be trying his best to do what he's doing, but what he's doing right now gives the court serious concerns or pause. I don't believe that the magistrate in setting the bond, I think that there has been an abuse of discretion. I'm going to set the defendant's bond in the amount of $50,000 cash as surety bond.
Okay, the defense is asking for leniency because the defendant has been following his bond conditions and trying to get help. But the judge isn't convinced that's enough. He points out that this man had just come off parole, and now they're back in court again for another alleged OWI. Look at the judge's body language. This is no longer about giving someone the benefit of the doubt. Then the judge announces a dramatically higher bond. But there's a twist.
No 10%. I will, however, do this. Make a decision. You said that the money was paid on a credit card sometime. I don't have a problem refunding the bond that he's paid if he needs those funds to pay for inpatient treatment. So he can be released to inpatient treatment. I'm phrasing it that I'll consider release to inpatient treatment. I'm not saying on a PR at this point. But if he needs those funds and you let us know that he needs those funds to get himself into inpatient treatment, I'm not going to have a problem with that. I want him to have help. I want him to not deal with it. I want him to be able to deal with the demons that face him. And I don't want him here on an OWI causing death. And I think that I need to protect the community, and that's how I'm going to do it.
Okay, Your Honor. Can I ask to approach, please?
You may.
Thank you.
All right, record should reflect that we had a bench conference just in terms of the details. And again, so that I'm very clear on the record, I don't have a problem refunding what's been paid, provided that goes to inpatient treatment.
Okay.
All right. And so I just need you to arrange that, get with the prosecutor. You guys get me an order and I'll sign off on it. Make sure if there's a cost to the inpatient treatment and you want the bond returned for the payment of that, make sure that portion is contained within the order.
Wait! This is not the ending I expected. The judge sets a $50,000 cash/surety bond, but then offers a possible path toward inpatient treatment. Sai is basically saying, I'm protecting the public, but I'm not giving up on you. The judge even says he wants a defendant to get help and deal with his addiction, instead of ending up in court over another dangerous incident. Accountability and compassion at the same time. And that's where these three courtroom battles come together.